Good evening to all. Myself Devashish Kaur, a grade 1 judicial officer of Tripura Judicial Service. In our second session, Manoj Prasad sir told that prevention is better than cure. So in the last year, I went to a religious place outside of Tripura. In the night, I came out from my hotel to visit the temple and found a group of so-called sadhus were consuming ganja. And in another side, a group of beggars having impaired limbs were lying on the ground. So first of all, the sadhus who were consuming ganja, consumption itself is a punishable offense under NDPS Act. So for the purpose of consumption, somehow they are storing and possessing those ganjas and purchasing those things from somewhere else, and someone is supplying them. In one side, they are doing some offenses under NDPS Act. In another side, the impaired limbs beggars are the victims of maiming and human trafficking. But it is a place of religious sentiment where public sentiment is attached. So how such kind of offenses can be prevented in such kind of religious places? Thank you.
It has to be answered. You want that what are the methods, what measures can be adopted? Now, what I observe that it is an administrative problem. Religious places or religion cannot come in the way of curbing such type of menace. So you would have reported to the local police station or the head of the corps to take initiatives,
these are the
measures
practices
that can be done.
These are the practices going on in,
Yes,
I think,
but
in
it
all
has to
religious
be-
places.
It has to be brought to the notice. It is not that the courts can take suo motu cognizance, but the officers are concerned, it has to be brought to their notice. That will be done. You make a report. Yes.
Thank you, Lordship.
Good evening. I am Shankari Das, District and Session Judge, Khwai. Just I wanted to point out a small thing. From the slides of Brigadier Guleria, some paper clippings were shown. And in those, probably two paper clippings, two pictures are there. Security personnel were standing with accused persons. And in front of them, the seized contraband items were placed. Now the point is, this is at the investigation stage, and accused persons are already identified. I think that it will have adverse impact during trial. So how do you address this issue?
Hello. Ma'am, point taken. We, Assam Rifles, are empowered under NDPS Act. We don't have the investigative powers. We only do the search and seizure. So once these items are seized, we hand it over to the police jointly. But this could be leaked to the press. From our side, we will take efforts to at least cover the FSS. That point is taken. But we are not into investigation. We only search and seizure.
No, whatever it may be, identification, the point of identification of the accused persons. So later on, it may have impact.
Those people have been, what we catch, they caught in the act jointly with the police. And there is no chance that we catch innocent. They are caught in the act. And we do have our checks like independent witnesses to confirm the same with the people we are catching. But with regards to that being photography being done in the papers, that is your point is taken. They should not be done. That we'll look into it.
I'm District Judge, I'm Nurain Khan, District Judge, West Jaintia Hill. With the permission of the chair, I've heard a lot about the accused persons being enlarged on bail. So, on the legal aspect, there is one question. I think there is conflicting judgments of the different high courts. If a charge sheet has been filed without the FSL report, as we have noticed, I believe all the special judges of the NDPS, they encounter this, that when the charge sheets are filed, there is always a delay in filing the FSL report. Now, whether a charge sheet which has been filed without an FSL report, is it to be considered as an incomplete charge sheet? Because there is a serious consequences. It leads to a default bail. If it is considered to be a incomplete charge sheet, it will lead to a default bail. And if it is a complete charge sheet, because there is a conflicting judgments, so I believe it always bothers us. That is one aspect. Second aspect with regard to the bail and the restriction under the NDPS Act is concerned. We had a recent decision of the Hon'ble Apex Court granting bail in a commercial quantity, because it struck the balance between non-granting bail, statutory restriction, and delay in trial. We had a Supreme Court judgment in 1994, Supreme Court legal aid cases. It says that a person cannot be kept under detention in spite of there being a restriction under Section 37. The delay, it infringes the right of the accused person under Article 14, because the personal liberty cannot be curtailed except by following procedure established by law. And the procedure established by law has to pass the test of being fair and just. So the restriction under Section 17 cannot be stretched to that extent that a person can be kept under detention without trial. So these are two questions. And finally, I just filed that a lot of cases get scrambled up during trial, because this NDPS law is the only law, what I find, if I've correctly understood, that a person is punished for not doing anything, but for being in possession of a banned substance. So the recovery and the seizure is the most important part of a criminal trial under the NDPS Act. And then we find, I'm surprised that why are we not using this technology, that the entire seizure has to be photographed with a certificate under Section 65B. It does away with all the independent witness, because when the Act came in 1985, we never contemplated that we'll have such kind of a technology. So far as the seizure of the drugs is made, if we have the law, statutory provisions provide that two respectable independent witnesses has to be present there in order to confirm the seizure. Now, to deal with this situation, the investigating agencies always they find difficult in getting some independent witnesses. The entire seizure has to be photographed and with a certificate under Section 65B, whether that is permissible or not. Thank you.
I think you hand over the mic to Manoj Prasad. I think in the second session, much emphasis was laid on the complexities of the law in that. Manojji, I would request you kindly address it.
The question was in different parts. Let me come on to the first part.
Yes.
The charge sheet submitted without FSL report. Yes, this is being done everywhere. The reasons we know, this is why we have an interdisciplinary functions, where persons from the police, persons from the judiciary, everybody is present, so that we can understand the hardships. We have to understand the hardship of police. The police has to understand our requirements, that what we need to proceed in a case. This makes these types of functions to be very useful. But anyway, still trying to answer his question, that if there is no FSL report, what is required to be done by judicial officer, as per my own understanding, is that we will delay the taking of cognizance. The charge sheet is not incomplete. We will not take cognizance unless we finally get the FSL report. But prima facie, in the charge sheet, there is a mention that we have used the kit. It is a scientific method. And the kit prima facie reflects that yes, the goods were psychotropic or it was a narcotic substance. So prima facie the material is there. It has to be substantiated by a report. The report comes, take cognizance. Now, releasing a person on bail. Generally, as we find that most of the quantities are small quantities because various players are introduced. So small quantities, the bail is being taken in a liberal manner. Police definitely has a frustration that after so much of effort, we arrested somebody, within 6 months he is released on bail. But as a judicial officer, can't we take a caution to get a criminal antecedent report? Because if the person is dealing in small quantities, he will be dealing several times. So if that person is dealing in small quantities, but he is a habitual dealer, we can refuse bail, irrespective of the quantity being small. So actually granting of bail or non-granting of bail is a factual answer. It does not have any standardized method ki you can answer it in a particular manner. So I think the two aspects which have been raised stands answered.
Yes.
If anything else is there, can I understand that?
Yes, Manojji, thank you. Take your seat. I think it is answered. Now, concluding remarks. Brother Justice Goud, Judge Tripura High Court, in very short, highlighted everything. DGP Amitabh Ranjan ji focused on, because of the coordinations among the countries, terror funding to some extent have been checked. Role of financial institutions in curbing terror funding, anti-money laundering at international level, AML, CTF, FATF, blacklisted countries. India shares border with 7 countries, 18 states and 92 districts are affected. Brigadier Guleria, he focused on geostrategic vulnerability, means of terror funding, also focused on borders of Myanmar, unfaced and porous border, problems faced by our country. Now, when Brigadier Guleria was speaking, it reminded me of Director Ames. At the time of COVID period, Director Ames, Dr. Guleria was also always on the television, so it reminded me of Dr. Guleria. Now second Guleria is here with Brigadier Guleria. Now both have played their role in life saving, one doctor there and Brigadier here. Similarities are there. Now I should say that problems are there, but we have to find solutions. And the resources available, in that only solutions can have to be found. Now, Inspector General of BSF, Matthew Burgess, DIG, all right, DIG BSF, I hope you will be promoted to IG. Now, it was focused on illicit drug trade, human trafficking, terror funding in cross-border, legal solutions. Really, we are enlightened. Deputy Inspector General of Police, BSF. To curb the menace, many steps were taken and urged before us. Now, we salute the police force, army, and whoever who are guarding our borders. Let me tell you, after all, the role of judiciary is also to safeguard the nation. By safeguarding our constitution, we are similar to you. You are guarding the borders, we are guarding the country by safeguarding the constitution. Biggest similarity, common factor. Let me tell that we are enlightened by the experience of Special Charge NDPS, and I once again thanks the Chief Justice of Tripura High Court, Brother Justice Sapresh Singh, who was keen to organize this function and who gave us opportunity to be here. Thank you, sir. Thank you once again. Jai Hind.
Thank you, my lord. Before concluding this session, we would like to honor the dignitaries on the dais by a small token of gratitude. I would request Learned Judicial Officer, Tripura Judiciary, to kindly present the memento to the dignitaries on the dais. Thank you. With this, we come to the end of the third technical session and the session of the day. This session will be followed by the valedictory session.
We have almost come to the end of the program. This is the valedictory session. I would humbly request Honorable Mr. Justice T. Amarnath Goud to present the valedictory address.
Beloved Chief Justice Aparesh Kumar Singh ji, Shivanand ji, and all dignitaries on the dais, my pranam. Today, being the Tripura Judicial Academy conducting its seminar under the aegis of Tripura High Court. Cross-border organized crimes, NDPS, human trafficking and terror funding, etc., impact assessment and legal solutions. To this, the states of Assam, Bihar, Jharkhand, Manipur, Meghalaya, Sikkim, West Bengal, and my home state, Tripura. We all have participated. In the inaugural session, the welcome address has been addressed by our Honorable Chief Justice Aparesh Kumar Singh ji. And Justice Sanjay Karol, Judge Supreme Court of India. He has enlightened us and shared his warmth with the relation he had with Tripura and also on the topic of narcotic drugs, classifying organic drug and synthetic drug and the ill effects of being addicted to it. Justice Aniruddha Bose ji, Judge Supreme Court of India, he also addressed on the issues of border and the drug menace. In the ceremonial address, the guest of honor, Chief Minister Dr. Manik Shah, while addressing the issue, he has drawn the attention about filing of cases, registering of the FIRs, pendency and the investigation and the filing of the final reports. And it draws the attention that for the past 2 years, only 30% of the cases are due to be filed their final reports, and about 70-75% cases are intact. In the technical session, number 1, offences under NDPS Act, impact assessment and legal solutions. Chief Justice of Sikkim, Vishwanath ji, has given an elaborated information, followed by Justice J.C.N. Gupta, Judge Calcutta High Court, on synthetic drugs, and further an elaborative presentation on NDPS by the resource person Sudhanshu Kumar Singh, Zonal Director of Narcotics, and Sri Sudipta De, the District and Sessions Judge of West Bengal, has elaborated on the organized crimes of narcotics. In the session 2, changing facets of human trafficking, role of enforcement agencies in curbing its menace. Justice Chakradhari Sharan Singh Ji, Judge Patna High Court, he has enlightened us on human trafficking and organ transplantation which is made for sale. So, the same by Justice Manish Chaudhary Ji, Judge Guwahati High Court, on the legal position of human trafficking. Mr. Manoj Prasad, Chairman Commercial Taxes Tribunal, Jharkhand. His words were eyebrow raising and practical to the core, and certain new issues on Motor Vehicles Act and the way the organized crime, which extends up to sale of human organs, was really an eye-opening, which so far I am concerned, it came to me as a surprise. And the final session, Technical 3, terror funding, a challenge for bordering states vis-a-vis international approach for its control and combat. Dr. Shivanand Pathak Ji, Judge, Jharkhand High Court, he made an elaborative speech on funding, terror funding, smuggling, fake currency, unlawful activities, its prevention. And for my surprise, sir, the notes what I prepared was delivered by you. About 15-20 pages with the assistance of my judicial officer. Thank you, madam. Director General of Police, State Tripura, he gave us a slide presentation and elaborative presentation covering 9/11 and the American issues and covering the problems of where India faces with regard to the border issues. The same with Brigadier Vikram Gurela ji, and carried forward by DIG Matthews and Mr. Alek, Special Judge, sharing his experience as a judicial officer on IT and social media, how it has been misused. Concluding this valedictory session, I thank the Chief Minister, the Chief Secretary, the DGP, and all the judicial officers and the teamwork which has been taken up, including the catering and the media and the Margadarshi, our Chief Justice Aparesh Kumar Singh Ji and Justice Arindam Loth and the Director Judicial Academy, all have made it a success. I thank one and all for coming here and making this program a success. Thank you.
After an engaging day, we have come to the end of today's seminar. We shall all rise for the national anthem now.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे तव शुभ आशीष मांगे। गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
I'm afraid I have one small final announcement to make. We'll have light refreshments. We have again arranged it in multiple places for the convenience of all our guests. The honorable judges and honorable dignitaries will proceed towards VIP lunch number 1. Other valued guests will also proceed towards VIP lunch number 2. And the remaining participants and delegates will proceed towards the hostel building. Thank you and Jai Hind.